Nima Rahmani. He's a former federal prosecutor and the president of West Coast Trial Lawyers. Nima, thanks for joining us. So what does this decision tell you about the court's thinking right now when the justices decide not to fast track this case, let the Court of Appeals handle it first, and when they don't give a single reason why? It's just your petition is denied.
Well, the Supreme Court is a court of discretionary jurisdiction, and granting cert or an appeal before a judgment in the Court of Appeals is rare. Obviously, this is a unique case, and we all know that delay is the friend of Donald Trump. If he wins in November and regains control of the White House, it's well established that a sitting president can't be prosecuted. So it's in his interest to push this out as long as he can, especially because there's that stay or that pause in Judge Chutkan's case in the D.C. court.
Yeah, and there's always questions, too, about what her jurisdiction, Judge Chutkan, would actually be over the course of this appeals process and potentially a Supreme Court. Now, look, Special Counsel Jack Smith, and part of his argument, pointed to a Watergate-era case in his brief. In that case, the Supreme Court, they leapfrogged the appeals court to quickly hear a case in which the justices ultimately rejected then-President Richard Nixon's claims of presidential privilege in a subpoena fight over Oval Office tape. So if you were a Supreme Court justice here, would you also have rejected Smith's argument?
I would have accepted the case, but we know during the Supreme Court conference, it takes 4 justices to agree to an expedited appeal. And the issue now is the D.C. Court of Appeals is going to hear oral argument in January, and it may take months for them to issue a decision. And unless this case gets on the court's calendar and there's an oral argument by April, the Supreme Court isn't going to hear this case. So that's going to push this out. The question is, does that stay in place? Is there the pause in the proceedings? And if so, then we're likely going to see this heard, if at all, during the Supreme Court's next term.
And that's part of what Jack Smith was arguing, that the gravity of this case requires the Supreme Court to look at it right now or as soon as possible, as opposed to going through an appeals process where, in theory, either side would be appealing whatever is decided at that point. Now, as you mentioned, the appeals arguments, the first one scheduled for January 9th, and you alluded to sort of what the timeline could be that we're seeing, but you've worked in the legal system long enough. I mean, how long of a purview are we looking at here when you consider going through an appeals court and then potentially the Supreme Court as well?
Now that there is no expedited appeal or cert before judgment like we saw in United States versus Nixon, or some of the other cases, frankly, that Donald Trump handled. He expedited death penalty cases, for instance, with his Department of Justice. It's going to be pushed out months. There's really no set timeline for the D.C. Court of Appeals. They may issue an opinion sometime this summer or well into the fall. There's no specific guideline for them. And then, of course, once that order comes out, then we have to see if the Supreme Court agrees to take the case. Again, they have discretion, and if so, they're going to set a briefing schedule. But probably we're looking into well into 2024, maybe even 2025 if it goes through the normal process.
Yeah, so, and obviously that would be after the November election, to which so many are looking this as a critical point, specifically with what the president is charged with in this particular case. Nima Rahmani, I got to leave it there. Thank you so much for being with us.
Thanks for having me.
Now we want to shift to the unprecedented migrant surge at the southern